executed with military precision. Let me agree with my learned friend Mr. Mahad on the use of the word military. He says military grade, but I differ with him to say the rigging was executed with military precision, and given the evidence that has been availed, using expert, foreign, and I'm now using another military word, mercenaries engaged for that purpose. I am not surprised that none of those gentlemen I'm referring to as mercenaries have not sworn an affidavit. People like that disappear and leave the country to its own devices. By the grace of God, we have remained peaceful, and I pray that we continue to do so. And finally, I will yield the floor to my learned senior, Mr. James Ray.
Milady, Madam Chief Justice, we would like a clarification from the court whether the replies and responses relate to questions of law that have arisen from our presentation, or whether it is an opportunity for our learned colleagues to rehash their case afresh and to introduce new evidence.
We know what constitutes a rejoinder. It's a response to issues of law arising from the respondent's response. So just to remind Council, it was about responding to matters of law.
Madam Chief Justice, I also rise to take or to request a clarification. The court was treated to a so-called live demonstration. Shall we be given an opportunity? We don't require more than 3 or 4 minutes to indicate that what the court was shown is not true. Because otherwise, this image is now all over the country, a sensational image about forms with the names of people, while as in truth, that is not correct. All that I would request you, Madam Chief Justice, is an opportunity for rebuttal. On the basis that that is new evidence, it was never played, those are not polling stations in the petition, it's totally new. It will be unfair for us to walk away without being given an opportunity to defend ourselves.
Unless the court walks away from the questions that the court asked, you asked for a demonstration of how the staging was done. It was a specific question. And similar questions were asked to our friends to the left. A lot of new material was brought in. We kept quiet because we knew these were questions from the court and that no evidence should be kept away from the court in the search for truth.
What we are doing, and then at the end of it we'll consider, because we are also checking whether that is new evidence. Yes.
I thank you. I begin by thanking the court for giving me this opportunity to make my remarks as part of the rejoinder for the petitioner. My lords, when I used to be at Alliance High School, every year, Professor Gidu is very happy about me mentioning his school. When I used to be at Alliance High School, every year I took part in a school play. Most of the time they were Shakespearean plays. Macbeth, Julius Caesar, Much Ado About Nothing. Can I recover my 4 seconds? Yes, I was saying I acted in every school play for 6 years. And when I became a practitioner of law, I tended to have the habit, every time I would appear in court, to take some verse from those Shakespearean plays, be it a comedy or a tragedy. And one time, S.M. Otieno, from whom I learned a lot as a young man in the practice of criminal law, he told me when I took my seat, did you read the charge? Did you look at the statements? Did you analyze the elements or the ingredients of the offense? Always remember, as a lawyer, that oration is not good enough. Substance counts when you appear before the court of law. And I'm saying this because in 2017, when he had a similar petition before your lordships, some of the advocates who are in that petition, acting for the respondents, when we presented our petition, said that what we presented before the court was a science fiction. And I'm not surprised that even at the beginning, and it's well covered in the media, that what we have presented before you is fiction. And because it is fiction, you had a lot of speeches which I think do not belong to a courtroom. They probably should have been delivered in some theater where people love poetry, like my learned friend, Professor Gidu Muigai, whom I know, having attended the same school as I did. We share a lot of things in common. We have presented before your lordships a petition based on averments which are contained in the petition. We have placed evidence before your lordships, and the petitioners did not ask the petition to be struck out. Instead, they filed volumes and volumes of affidavit evidence, and I've addressed you at length on matters relating to the petition. And yesterday, I remember when your lordships and my ladies asked questions to the respondents, my learned friend, Mr. Gidu Muigai, said those questions were difficult questions, but they are not as difficult as the questions which were directed against the petitioner. But having said that, there is an important point about this new constitution. And I'm so happy that your lordships and your ladyships, some members of this court, were part of the process of drafting this constitution. And my lady Justice Njoki asked a question which was very pointed. Why did we create these commissions? Why did we create these independent offices and secure their tenure in the Constitution? And the answer is that we are dealing with an imperial executive. The commissions became an insurance policy for the protection of the sovereignty of the people. And if you look at Article 249, the commissions and independent officers are required to protect the sovereignty of the people. And what better tool to use in order to protect the sovereignty of the people than to have fair and free elections conducted by an independent body. And this constitution requires that the elections must be transparent, and they must be administered in a neutral, efficient, accurate, and accountable manner. I would have hoped that if the Electoral Commission was indeed carrying out an election that was free and fair, transparent, and accountable, they will be offering all the evidence, including what is in the servers, that this is what went on, this is the record, this is the return of the elections that were held on the 9th of August 2022. I thought that we were making progress. Your lordships and my ladies, there was a time that we used to file petitions against even the President of the Republic of Kenya under the old constitution. And if you approach the Electoral Commission before you file the petition, you had access to election documents and election materials before filing the petition. And I did that so many times. My other friend Firoz Norji will tell you, because I was a petitioner. And he filed such a petition. Now, to get information from the Electoral Commission even after filing a petition and an election has been conducted is like the road to hell. Because that's what it is. And in Article 249, the sovereign, who is the people of Kenya, require of the Electoral Commission as a state organ to secure the observance of democratic values and principles and promote constitutionalism. Not just in the conduct of the elections, but even the way it runs its affairs. They cannot pretend that they are conducting elections and valuing and securing the principles of democracy as contained in Article 10 of the Constitution, and yet within the body itself, they don't value these principles that are not discretionary. They are, every state organ, every person is required to act in accordance with Article 10. What does the chairperson of the Electoral Commission do in the circumstances, not only of this case, but even in previous occasions? In the Electoral Commission, instead of having a commission of 7 commissioners, and you have seen the factionalism here, you have a triumvirate, you have a trioca that is moving together all the time with the secretary of the commission. This is not what the Constitution desired or contemplated. If you look at Article 88 of the Constitution, the mandate of the Commission in relation to the supervision of elections and referenda, at the end of that Article 88, and I think this is important, Sub-Article 5, the Commission shall exercise the powers and perform its function in accordance with this Constitution and national legislation. So that where the chairperson comes before you and does not show conduct that is in consonance with the Constitution, is that a matter that this court can just gloss over? When the Constitution says in Article 2 that this Constitution is the supreme law of the Republic and binds all persons and all state organs, and no person may claim or exercise state authority except as authorized under this Constitution. And throughout that Article 88, the Constitution throughout talks about the Commission, except in two instances, one of them being the declaration of the results in a presidential election. So I urge my ladies and my lords that where there's been an infringement of the Constitution, however good the outcome, but there has been an infringement of the Constitution, because the Constitution says how we should conduct elections. It does not matter whether you get 10 million votes or 20 million votes. If you get it by murder and killing people, if you get it by falsifying documents, however the numbers you end up getting in an election, that would not be the kind of election contemplated under Article 81 of the Constitution. To state officers, including the President, including members of commissions, any infringement of the Constitution normally would attract consequences of removal, impeachment, because it's a matter that this Constitution frowns on. And that's why I always appreciate the fact that this Constitution requires of citizens, every person has an obligation to respect, uphold, and defend this Constitution. This petition is in defense of the Constitution. Is in defense of the Constitution because there is an election that has taken place that is putting somebody in office, or is attempting to put somebody in office without meeting the requirements of the Constitution, not only in terms of, not only quantitatively in terms of votes, but also in terms of what the Constitution requires the conduct of elections to be like. And my learned senior, Mr. Firoz Nehruji, referred to a football match. These days, football has many rules, and they keep on improving. However many goals you score, if it is from an offside position, whether you're Messi or Ronaldo, it will not count. It will not count. So I urge the court, and I am an optimist. I think we are doing very well in this republic. I think we have come from very far. And as one who has practiced in these courts when things were extremely difficult, I know we are making progress, a lot of progress. There were times to file a petition like this was not easy. And if you file it, serving that petition will be very difficult. And that is not just because of legislation and a new constitution. The courts had made an intervention many times to protect the people against those who govern them particularly. And therefore, invite your lordships that looking at the article dealing with leadership and integrity, what has been placed before you is not a matter that the court can frown on, gloss over. This court said in 2017 in the Raila petition that if the Electoral Commission comes before you with the same kind of infractions and transgressions, this court will not hesitate to take measures against the Commission and its leadership. That is in the Raila judgment of 2017. In 2013, this same Commission, fortunately for the chairperson, he was not there at that time, despite the fact that that petition was not allowed, but the court was not amused by the going-ons in the Electoral Commission, and by dint of the comments that were made by the court at that time, at least a few people were taken to court, although that case is still going on. I think this court, and reading the Supreme Court Act, Section 3, together with Article 259 of the Constitution, which talks to how this Constitution should be interpreted, and more particularly when it says in a manner that promotes the values, the purposes and principles of this Constitution, and contributes to good governance. So I urge this court with all the humility that although this is a petition basically under Article 140, as defenders and protectors of this Constitution, you, with respect, cannot allow what has happened at IBC to go without some kind of action in the lines that was suggested by my learned senior, Feroz Norji. Impunity must be punished. Impunity must be punished. And impunity unpunished breeds arrogance. And arrogance leads to arbitrary exercise of power. And without that being done, this commission, which has got the protection of the Constitution, without the court making some interventions, it still be a divided commission with a triumvirate that runs the affairs of a commission that is supposed to protect and defend the sovereignty of the people. And what I'm saying in a nutshell, that this election cannot pass on account of violation of the Constitution, even by the constitutional dictates how this commission should run its affairs. If they cannot conduct their affairs in the manner dictated by the Constitution, then how can they preside over an election, and that election have some legitimacy to the people of Kenya and to the world? Secondly, and this would be my last point, that if you look at Article 138, sub-article 4, and my learned friend Mr. Otiende addressed you on this, that requirement for a successful candidate getting 50% plus one of the votes cast is not an idle provision in the Constitution. It requires of the Commission to come with it before your Lordship seriously when there is contestation and put the numbers before you in rebuttal to the case that we have put before you. My little friend, Mr. Mahat, who is also my very good friend, in his address, he was not talking about what the law requires or what the Constitution requires. He was saying, this is what we do. This is what the Kimskits do. There was no constitutional or legal foundation that he was resting his arguments. And therefore, yeah, my ladies and your lordships, I would ask the court to apply the provisions of the Constitution to the letter holistically and allow this petition and return this country and back to the people who are sovereign, and let a proper choice be made of the person who is going to lead Kenya in the next 5 years.
Your Ladyship, Madam Chief Justice, Your Ladyship, Madam Deputy Chief Justice, Your Ladyship, and my Lords of the Supreme Court. The petition that was filed by the first petitioner, to recap it, was a very simple, by the second petitioner, I think we are the second petitioner as amended, was very limited to a legal issue. It was, what was the position vis-a-vis the election and the role of the commissioners? Now, yesterday, and I think Justice Lenola said something about tweeting and stigmatizing, but in a nice way. When this petitioner came, and I had said it in my opening address, and yesterday Mr. Ngatia said, senior counsel said something very, very, I mean, it's our country. He said, this is one country that even the humble can go to the top. But there was a caveat that seems to have been missed out. If you are a normal, humble person who comes to challenge a presidential election as required by the law, you still get targeted as being a surrogate, because that was repeated 3 times. So there seems to be caveats in these things that we don't seem to know about. Yesterday, my lady, Justice Njoki, asked a very direct question. What is the role of these 6 commissioners and the chairman? Because we seem to be getting in a very empirical chairman. This morning, we got absolutely no idea, except the court was taken to Section 11A and B of the IEBC Act. We were told nothing more. From what I can now see is that these 6 commissioners are supposed to be flower girls and page boys at a wedding, with the chairman being the bride or the bridegroom, as the case may be. That surely was not the intention of the Constitution. It appears that that's because I was actually waiting for that answer just as much as your lordship and lordships and ladyship there was nothing given. Please go to 11A. That's all you were told. We have an umpire, and I'll use it in the cricket term because in football it's called referee. But here in the cricketing terms, it's called an umpire. It is supposed to be an independent umpire. But I heard some I was a bit surprised yesterday when I heard words like shock and awe tactics. And surprisingly, the shock and awe tactics actually came out in one of the protagonists' The ones, the protagonists of We've Won, and that was in one of the affidavits. And these are the direct words that an umpire is using. So how is this umpire as independent as they are claiming to be? That is my client's case, that we need an independent body. The second one, we were told by the umpire, get over it, quote, unquote. We were told by one of the protagonists, move on. If there has been a breach of a constitutional, and as it has been our submission, Article 138, 3C, if there is a breach, do we just move on? That's what we are being told. Forget the transgressions that anybody is doing. Justice Lenola, in the opening day after the petitioners had made some submissions, asked a question which I didn't see anybody answering. He asked a question regarding Regulation 87.3, where he had stated that if it should be struck down, but it's already been done, so, that was the regulation which was in place. If your lordships and your ladyships will look at my submissions, my original submissions we had filed, and we specifically addressed that issue. What is a nullity is a nullity, and I believe it is in the McFoy case, it's an English authority, that we have quoted in our original submissions. So I hope, Justice Lenola, it answers your question.
Thank you.
Because I think nobody here actually took those questions seriously, they didn't answer them. And I don't mean to be disrespectful or being facetious at all. As far as from what I can see, is that this, by the law, by Article 138, 3C, it says commission. We were told commission, but it doesn't say commissioners. That was a distinction being made yesterday. It says commissioners, doesn't say commissioners, but commission. With due respect, all those commissioners are appointed, well, not at the same time, but go through the same rigorous process. Does it mean all animals are equal, but some are more equal than others, which means the chairman is more equal than anybody else? These, like I've said, and I repeat again, are just flower girls and page boys? That surely cannot be the intention, could not have been the intention of people who drafted this constitution. We go back to where we started from, and I've said that in my original submissions. Where did we come from? We need to know where we came from. One-man show? Surely that cannot be the issue. The other issue that the Chief Justice asked yesterday, why was it not declared to everybody? And that's where my client, that there were all these problems, these commissioners had walked out, the transparency, accuracy. Nobody has given us that answer as we sat through this today. You specifically asked, Madam Chief Justice, why was it not declared that there were these problems, 27 constituencies? Nothing. We couldn't do it because there was a problem. I don't want to go into Maina Kiai case, but you were quoted paragraph 287 of the Supreme Court, which I called RILA, which was RILA 1 or 2. But please, before just looking at 287, please look at paragraph 292 of this court's decision. I don't want to repeat it, but this court specifically said, it is in my original submissions, we fault the appellant, who was the IEBC, and the chairman, who was the current chairman, for there being no verification by the commission. We've been told we've misread the section because it's polling stations. With due respect, if it was going to be only polling stations, why send it to the National Tallying Center? It is for the public to know there were mistakes here, there were no mistakes, whatever else there was. A question was asked by the court yesterday. Why did the running tallying stop? Nobody's given us an answer. All the difficult questions that we were to get answers for, to which my client, as a voter, and as Wanjiku, I keep on saying, we have not received any answers whatsoever. No affidavits. In fact, the sad part is, despite this whole matter being consolidated, we were considered the surrogates. Nobody sent us any papers to sign. I have two requests from this court, as I have said, and this was what I was thinking of last night before I went to bed. Where it is established that a state officer is subverting the Constitution and the rule of law, the court's hands are not shackled by procedural niceties. This is the beauty of this Wanjico Constitution that we have. It's transformative, and some people say it's a very overused word, but in these circumstances it's ideal and can bite when occasion demands. The toothless bulldog is long dead and buried. Please, Madam Chief Justice and honorable judges of this court, bite and bite for the glory of this court. And in closing, whilst we said, we were told our petition is much ado about nothing, and like I said, we've really been battered, but we shall soldier on. I will use Martin Luther King's words, because I suppose, unlike Professor Guido Muigai and Mr. James Orengo, I went to a school where they didn't teach us Shakespeare, they taught us Things Fall Apart. They went to the posh schools. And all Martin Luther King said in 1968, at the speech given at the National Cathedral, we shall overcome because the arc of the moral universe is long, but it bends to justice. That's all we request. Can we have justice for all of us, for the voters? Because the two parties just think about themselves. They forget us, who are the voters. Thank you. And I donate my 4 minutes back to the court.
Thank you. We will have the third petitioner, Youth Advocacy Africa, and Peter Kireka.
Madam Chief Justice and Madam Deputy Chief Justice, and may it please the members of the court. Yesterday, and for a section of this morning, Your Ladyship, I believe we've been allocated 30 minutes. I see the clock says 15. The directions clearly said 30, they were. But the directions said 30 clearly.
No, the directions I have.
Yes, for youth.
Yes, for youth advocacy is 30 minutes.
30 minutes, yes. I think the clock said 15. Yes. I was a bit concerned, yes. But for yesterday, for most of yesterday and this morning, members of the court.
Sorry, Counsel, yes. For our record,
yes.
Introduction.
Yes, Your Lordship. My name is Tom Sharia. I appear together with my colleagues on record for Youth Advocacy Africa and Peter Kireka. Most of yesterday and this morning, you were treated to the theory of an election as it ought to be conducted. My colleague, Julie Soweto, has demonstrated to you what every Kenyan knows. Mambo kwa ground ni different. I call your attention to the affidavit yesterday presented by my good and learned friend, Professor Kindiki, which has been projected. It's the affidavit of Veronica Ndwati. She deposed that she is the Secretary General of United Democratic Alliance and was the Deputy Chief Agent for the 9th and 10th respondents. In particular, I call your attention to paragraph 7, where she states that the verification process went through a 3-tier mechanism. At paragraph 7, she says the second tier was at the constituency level, where the following actions were undertaken. She then goes to subparagraph C, and that is the one of interest here, and this is what she says. In case of any errors, this is at the constituency level, on Form 34B, the same would be corrected. That is the key. Those are the key words. She then goes on at paragraph 8 and says that the third tier was at the National Tallying Center at Bomas of Kenya, where the following activities took place. We go to paragraph 8F. The verification team would also verify that each of the uploaded Form 34A in the public portal is a replica of the original 34A presented by the constituency returning officer, and in instances of discrepancies, the errors were noted. She then says at G, the team would also verify that the data entered in the IEBC online system for purpose of tallying from all original forms was correct. In case the data entered in the IEBC online system is incorrect, the same was corrected on the online system. She then goes at J, a verified Form 34B would thereafter be generated at Bomas. Another one, having corrected at constituency, another one now is generated at Bomas and supplied to the candidates' agents. I specify these particular provisions because, members of the Honorable Court, this is precisely what the chairman of IEBC was told in the minor KI case he could not do. And it bears reading because, as has been repeated here severally, and perhaps I shouldn't repeat it too many times, he is qualified to be a Supreme Court judge. And so we know he understood minor KI. So it is important that we understand what he did not understand about the following passage. It is evident, I'm reading from minor KI, it is evident to us from the above sequence of events that the role of the chairperson of the appellant is circumscribed. Article 138 deals with events at the polling stations where votes are counted, tallied, verified, and declared. The appellant, that's the commission, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for election of president, electronically transmitted to it from near 40,000 police stations, is required to tally and verify the results at the National Tallying Center without, this is the key word, without interfering with the figures and details of the outcome of the vote as received from the County Tallying Center. Minor KI states further, the chairperson, on the other hand, is appointed under Article 250 of the Constitution. The chairperson cannot be and is not the commission. It goes on to say, and I say this because my good friend George Morogo this morning told you that whether the chairman is the commission or the chairman is a matter of context. It is not a matter of context. Minor KI put that debate to rest once and for all. And finally, to suggest that there is some law that empowers the chairperson of the appellant as an individual to alone correct, then that's the word, correct, vary, confirm, alter, modify, or adjust the results electronically transmitted to the National Tallying Center from the constituency tallying centers is to donate an illegitimate power. Such a suggestion would introduce opaqueness. These were the words used by the 4 commissioners who disagreed with what was going on at Bomas. Opaqueness and arbitrariness to the electoral process, the very mischief the Constitution seeks to remedy. I don't know how much clearer it can get that what the chairman of the commission did was the very opposite of what the Constitution required him to do. Now, minor KI was itself based on several decisions of this court. The first of those being Wanjohi, which is a 2014 case, and it is cited there, where the court said, apart from the priority, this court said, apart from the priority attaching to the political and constitutional scheme for the election of representatives of governance agencies, the weight of the people's franchise interest is far too substantial to permit one official or a couple of them, including a returning officer, unilaterally to undo the voter's verdict without having the matter resolved according to law by the judicial organ of state. The only organ under our constitutional framework permitted to correct at any level, let alone any of the 3 levels that the chairman of the commission undertook, is this court. It is manifest to this court that an error regarding the elector's final choice, if indeed there is one, raises vital issues of justice such as can only be resolved before the courts of law. We reiterate as we conclude that there is no doubt from the architecture of the laws we have considered that the people of Kenya did not intend to vest or concentrate such sweeping and boundless powers in one individual the chairman of the appellant. Now, as we stated, the chairman is an eminent lawyer, qualified to be a Supreme Court judge. It is extremely unlikely he did not understand what Maina Kiai had told him. And the only reason he would then have proceeded in the manner that Veronica Nduati tells us is that, to use another Kenyan phrase, mtadu, what are you going to do about it? That is the only reason one can find for what he did. Yesterday, the commission came and told you that the system was accessed thousands of times by officers at the Bomas. And so clearly, you had returning officers, specific special returning officers, assigned to changing forms on the portal, as has been demonstrated this morning. In our submission, the alterations made to this system, to the forms, these so-called corrections that were done at 3 levels, so alterated and contaminated the outcome of the election that it is now incurably defective and incapable of being rescued. Now, we were challenged to demonstrate from their own forms what the problem was with the forms. Now, time doesn't permit me to take you directly to those affidavits, but the commission has filed an affidavit through the firm of Iseme Kamau and Maema in our petition, the affidavit of Esther Wanjiko Wanjohi. She attaches 14 forms. That's about a quarter or 30% of the forms that you asked to be taken through the scrutiny. Of those 14 forms, 8, representing 57% of the forms, 8 have irregularities, have gaps, have problems, including the fact that when you read them with a QR code, the serial number that shows up is for a different polling station. The problems are correction problems, tallying problems on those forms submitted by the commissioners themselves, by the commission itself. You have an affidavit submitted again by the commission, the affidavit of Nzika Mwololo. Same problems. He has 2 forms. 50% of them, which is 1 form, has an incorrect addition where the rejected votes have been added as part of the total. Now, in light of what Maina Kiai said and what my learned seniors have said here this morning, my mind is taken back to a few months ago when a few of my colleagues here, my good friends here, came before this court and told you and persuaded you that a process known as BBI, one where 1 million signatures had been collected, one which had gone through over 40 county assemblies, one which had gone through both houses of parliament, was irredeemably void and null because the president used the wrong process. And they persuaded you. And I invite you to look at paragraphs 1544, 1535, and 1500 of your judgment in the BBI case, where you stated that any process, any activity undertaken without constitutional authority, as the chairman of the IEBC has done in this particular case, must be declared null and void. And the terms null and void, and this is one of the cases we've stated before you, the case of McFoy versus United Africa Company, is captured in the following words. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have a court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. That is the fate the Form 36, the Form 34D, issued by the chairman of the commission in this matter must suffer as well. Now, my learned friend, Mr. Mahat, has taken you through some numbers. And as I've demonstrated, and as was demonstrated earlier here by my colleagues for the first petitioner, when you have a process where the numbers are so adulterated, where the forms are so compromised, what numbers are we talking about? Numbers that have been verified or quote-unquote tallied in an unconstitutional matter. On senior, I think Mr. Orengo, I think it was Tinde Amolo Senior Council, said that the numbers became a moving target. Now, in fact, they were behaving not more like a moving target, but like a group of naughty children in a nursery school running around the yard. It is impossible to get a hold of the number that was used either for the 50+1 or for the tallying or for the verification, which, as you have heard, was changed 3 times. Now, you asked, I think, of the petitioners, how did we get to this place? Like every slow train crash, a train crash in slow motion, those of us who lived through the repressive days that led to the Constitution of 2010 will tell you that it did not happen one day. My good friend Mr. Morogo has told you that the Gazette notice by which the chairman appointed himself as the presidential returning officer. And we need to note, because the defense put here yesterday by the commission, was that he appointed himself on the basis of your judgment in 2017, where in passing, you said that there is a national returning officer. Now this year, he has upgraded. He upgraded himself to presidential returning officer. Now you've been told that Gazette notice means nothing. And I think yesterday you were told we ought to be grateful to him because he had the good grace to publish in the Gazette his unconstitutional appointment. Now, whether you publish misconduct in the Kenya Gazette or you publish an offense does not imbue you with some sort of value or some sort, does not imbue that process with some good grace or quality if the Constitution does not permit that office to exist or does not permit him to conduct himself in the way he did. A Gazette notice does not improve it. But perhaps more importantly, if it meant nothing, why publish it in the first place if it meant nothing? Why publish it at all if it meant nothing? But the point I wish to make is this. Complaints were raised. I think I've seen letters written by the party that nominated the first petitioner. There were newspaper articles complaining, Gazette notices, newspaper notices complaining that ballots had come without commissioners being told, but you'll get to hear that a bit more. There were complaints made by civil society. But as happened with Kenya, when we ended up in the position we ended up before the 2010 Constitution, we keep pushing these things away to the back of our mind. And people go to campaign, the rest of us go on with our lives, and he publishes a new Gazette. I am now the presidential returning officer. He goes on ahead and does other things, allocates duties. You go look after flowers, you go be an usher. These are slowly and then progressively, we end up with what was this morning called an imperial chairman of the commission. And so this is how we ended up at this unhappy day, where 4 commissioners say that we cannot stand by these reasons because we were not involved in everything that was done with them. But apart from that, and apart from those obvious misdemeanors and indiscretions that have been pointed out here this morning and the day before yesterday, in our petition, we've raised the fact that even other statutory requirements, the KPMG audit report, for example, was only published on the 5th of August, 4 days to the election. And parties kept asking for this report. Where is the report? And we'll all be told, again, in that most Kenyan fashion, tunashughulikia hiyo maneno. So you go back and campaign, go do your things, and you wait. And on the 3 days before the election, it is dumped on the website, And no one is actually told. There was no press release saying, we've released KPMG now. We had to find it there by accident. Now, when you finally go and look at that report, and you'll see a copy of it in the particular pages I refer you to, pages 1,153 and 1,155 of the year petition, you will find that KPMG complains that both the Commission and Smartmatic withheld critical information as regards how the voters register was being accessed, and that by the time the report was written and released, they had not received that information. That was the KPMG report. Now, again, the Commission comes here this morning and tries to explain to you how they arrived at the question of voters identified with the printed register. One of the things you will not find in the affidavits filed by the Commission is an account of how many Form 32As were signed as required by law. And that is the only mechanism that the regulations identify for identifying those who have voted outside the KIEMS kit system itself. And so what they've done, and that's what I think one of the honorable judges yesterday called a bit of a lecture here yesterday, is do reverse mathematics. You begin by adding up all the votes you say were in the Form 34C, and then you subtract from that those who were identified using the KIEMS kit. You have not been given a report of how many Form 32As were signed. In addition to that is the tortured question of Regulation 69, Sub-Regulation 1A. And I've not heard anything said about that here. Now, Regulation 69(1)A of the Election General Regulations requires that every time a voter is identified using the KIEMS kit, the printed register must be crossed out. And this is not a function of voter identification. This is an audit tool to ensure there's no fraud. A distinction must be made between what was before the Court of Appeal in the case raised before you about the printed register and what the law requires as regards the crossing out. For some reason, the Commission strenuously opposed this audit tool. Now, you've been told that there were approximately 92,000 stray ballots. Now, the mathematics that the Commission chair uses to arrive to that number, for starters, is not an accountable figure. What they've done, and you'll find that, I think, at paragraphs 73, 74, 75, and 76 of the chairman's replying affidavit in our petition, is taken two constituencies, this is Makadara and Kibra, and said that in those two constituencies, we had an average of 2 stray ballots per polling station. They take an average. And the reason for this is that it is not possible to account for stray ballots in Kenya within the time that this court must rule. Because under Regulation 81E, once stray ballots have been identified, they are put in an envelope, and neither Form 37B, 38B, or 39B have anywhere to indicate stray ballots. They are indicated in a polling station diary. The only way of arriving at a precise number of stray ballots and identifying to whom they strayed, if I may use that word, is to audit the polling station diaries for the 46,000 polling stations in this country. And that hasn't been done. And so we can't speak with any certainty here when a figure is thrown at this court that there are 96,000 or 92,000 stray ballots. No one knows. The truth is that no one knows. That's number one. The second thing is that in arriving at these mathematics, the chair of the commission says that in six polling stations in Starehe and Mathare, the officer locked up the forms in the ballot box. And he then says that in the 6, we cannot account now for 4,200 ballots. Now 4,200 divided by 6 is 700. What he's saying is that in those 6 polling stations, there was a 100% turnout. You will see that at paragraph 74, 75, 76 of the replying affidavit. Now, when you go to the forms on the portal, as we've been asked to do, the turnout is not 100%. And so that is a false averment in his affidavit. I think much has been said about the forms and the PDFs. I think I won't venture to say anything about that. I think I should also state, because it was part of our petition, that by the time we went to the election, and I think as of today, an audit report as required by the elections technology regulations has not been provided or done. It's not on their website, it's not been provided. The elections technology regulations under the Elections Act require an annual audit under Regulation 10 and 11. You will find in a response by the chairman to the first petitioner's party a letter where he says we could not do the audit because we did not have money. He has now annexed, in response to our petition, a certificate, a 2-page certificate, where they say we have 10 reports, but he doesn't attach those 10 reports. They are not on the website, and we have not been provided with them as of today. The purpose of that audit is that it might become impossible or unnecessary for us to spend time here discussing things called logs. And the only logs my grandmother knows are those she uses to warm herself. And yet she's the voter. We must, and I think we've submitted before you a case from the German Constitutional Court, which states that unless the public is able to, independent of an expert, audit the process used to conduct an election, then that election is not verifiable. That decision is before you with our digest of authorities. And it speaks to something a bit more nefarious, if I may use that word. We have just been told here today that we had foreigners who have accessed our IT systems. I can't pronounce their names on account of my county of origin. Now, and what has happened is that, and the submission I would make, is that the IEBC ceded control of the process of determining the sovereign will of the people of Kenya to a foreign entity that now says that that data is the intellectual property and cannot be shared with Kenyans. And there are very, very serious questions that arise. And I say this because they were asked of the chairman of the commission. For example, this data, they now say is theirs. Has it complied with the Data Protection Act? Was this company subjected to the provision of Section 31 of the Data Protection Act? And what are the consequences of surrendering our data, our biometric data, to foreigners who now tell us that is now their intellectual property? And I think Kenyans would be forgiven for saying that we're going soon to have leaders made in Venezuela, not in Kenya, not by Kenyans. Allow me to use the few minutes left to address some of the questions I think you raised, especially as regards remedies. But before that, let me just point out that amongst the other failures by this commission was to provide the Parliament of Kenya with amended regulations, which they promised to do last year, but presented amended regulations in June or July as Parliament was going on recess Sendai. And so again, they'll come and tell you the law was not amended for us to rectify some of these things, but they submitted their proposals late again and outside the election operations plan that they had said they would do. Now, printing of ballot papers, a specific question was asked of them. This company that you have procured, rightfully or wrongly, is accused of having led to the postponement of an election in Nigeria. And the chairman again said, there's no problem, tunashughulikia hiyo maneno. On the 8th, we have the largest postponement of elections in the history of Kenya. The elections postponed on 8th August was the largest number of postponements in the history of Kenya. So, what should we do? Kenyans who run into problems and who find complicated issues they don't know what to do with, I always want to say, do something. Can somebody do something? Somebody should do something. That is what we say. But this Honorable Court has the power to do something. And it has power to do something even in the face of an imperial commissioner, chairman of the commission, who quite casually says, Mutadu, do something. You have power under Article 140, and again, in my view, I think the question was asked here about the utility of Section 80, subsection 4 of the Elections Act. Now, I think given the time limitations that this court has to do a recount and a retally properly, that section is one that is not very helpful or useful. The requirement of the Constitution under Article 140, subarticle 3, is for a nullification of an election that is found not to have been in compliance with the Constitution. That is number one. Number two, I think the judge asked of us, what is to happen if we are to then find that this chair violated the Constitution or committed crimes? Again, that is a question that has risen here before. I think in 2017, we have an Election Offences Act. We have Article 251, which make provision for what is to happen to errant and imperial officers, public officers, such as the one whose case is before the court today. And so I think it would be premature to start anticipating what were to happen, because I think our Constitution has sufficient, and I think we must trust it. We must trust our Constitution and the mechanisms it has created under Article 140 and other articles for what is to happen in that eventuality. Madam Chief Justice, Deputy Chief Justice, I want to thank you for the privilege of your attention, and unless there are any questions left for me, I will donate my 1 minute back to the court. Thank you very much.
Thank you. 15 minutes given to the fourth petitioner, Khalifa.
My Lady Chief Justice and the court, may I plead with the court once again that what we are listening to is not a reply. It is a rehash of the case afresh, and it is leaving us in a very vulnerable position because new issues are being raised, and we have had, or may not have, unless you assure us, my lady, that we will have an opportunity to reply.
I think we have already cautioned counsel to reply on points of law, and you can see all of us are busy. We know what are points of law in our reply, and we know what to ignore.
This is only 2 seconds. You said that earlier. We all thought we had. Despite that, Mr. Macharia has taken 30 minutes to argue factual issues, going to affidavits, nothing on a point of law that he responded to. In my submission, therefore, the court will be perfectly entitled to disregard every word he uttered.
Yes, we know how to separate the chaff from the wheat, from the submissions. Yes.
My lady, before I start my submission so that my time doesn't run, I find myself in the position, I'm Willis Otieno for the fourth petitioner, in the unfortunate position that I'm one of the most mistreated petitioners in these proceedings by the first and second respondents. They served me late, as I indicated already in the pre-conference, and we lost the opportunity to respond, and this court did indicate that when we'll be doing our response, we can comment on some of those issues. We never filed a rejoinder to them because we were the ones who were served late outside the timelines provided by the court. So, but I don't intend to go deep into facts, but I may make one sentence references just to meet what had been allowed before, if that is in order. Number one, my lords and my ladies, we must assert that the KPMG report, the only expert report that has been done on the biometric voter register, that evidence has not been challenged by any other expert evidence. And that evidence which you annexed and referred to, we can now safely conclude that the 481,711 duplicates that are in that report, 481,711 is admitted. The second point that I wish to respond relates to the question my learned senior Professor Gideon Muigai said, that if these elections are badly conducted, not in accordance with the law, what about the other 5-tier elections where we have governors and senators? One answer: jurisdiction. Every court will have its day, every court will consider the facts of those cases. The third point that I wish to respond to relates to what was asked of when the regulations that gave the chairman the power to be a returning officer were passed. They were law at the time he acted. Simple answer: Maina Kiai case had already answered that question of what the law was. Maina Kiai case had interpreted Article 138(3)(c) of the Constitution. That was the law, and any regulation being made to circumvent that law by itself is unconstitutional. As I said, HELEF was a petitioner in Maina Kiai case. HELEF came to court. HELEF has come back to court to enjoy the fruits of his litigation in Maina Kiai case, and I was his proud lawyer in that particular case as well. My lords and my ladies, reference was made that the IEBC saw the ballot boxes for the first time that necessitated the postponement of the elections on the 8th of August. My lords and my ladies, Lycos never disappoints. You've just been told how Lycos, wherever they printed ballots, they've always ended up with postponed elections. IEBC should have exercised due diligence to make sure that even the pre-printing images are cross-checked and confirmed to be accurate. An admission that I submit is that IEBC was not diligent, and it must pay that penalty. It cannot transfer the consequences of their lack of diligence on the people of Kenya through fake elections. My learned friend Mr. Gumbo spoke on technology, and he gave us the Kriegler report. Kriegler report did not say deploy weak and vulnerable technology. Kriegler report required you to deploy sufficient, efficient, integral technology that protects the will of the voter. Kriegler report did not make a recommendation for Jose Camargo, Diego Maradona midfielder, to sit in the middle and start distributing results, as was demonstrated today in the morning. Kriegler report is not an answer or does not excuse a technology that the KPMG audit report has found and confirmed to be vulnerable, has 14 unauthorized users called Embakasi South cracks. The fourth point I want to raise is IEBC has confirmed that we look at the portal to tally the results. It is not the public portal that is used to tally. Tallying is a function of the commission. The commissioners must perform a tally of those results. And what is the commission vis-a-vis the secretariat? I refer this court to the case of Engineer Michael Kamau versus EACC, where the court specifically said the core functions of a commission cannot be performed by the secretariat. That was the Court of Appeal decision. It's part of the bundle of documents that we've annexed. You are told, my lords and my ladies, when in relation to the question of how integral the technology was, and my learned that Justice Lenaula did ask, when you take a JPEG and it comes out as a PDF, and I tie it to the response, what Camargo was doing in the system, and my learned friend Samane said, he's a plumber. He's like a plumber maintaining the system. Let me say this. Once a plumber has fixed your bathroom, that plumber has no business being in your bathroom when you're showering. If you find him at that time, you tell him, get behind me, Satan, as was said in the book of Mark 8:33 in the Bible, when the devil entered Peter And Jesus told him, "Get behind me, Satan." A plumber who is in your bathroom when you're showering after fixing your shower is no longer a plumber, is a sexual offender and should be reported.
Let's stick to the...
I'm guided. Mr. Somane took you through several forms, explanations, trying to explain what is voter turnout, the Kim's kit. At the end of the day, when you leave, are you able to answer the constitutional threshold, the question, are those results, or sorry, is that system of technology simple, verifiable, and accurate? Why the many explanations? Why the kizungu mingi? It should be simple, accurate, and verifiable. What we've been shown is not simple, is not accurate. This court is still left with so many questions as to the true Kim's kit logins, as to the true and exact turnout of voters as at 5 p.m. on the 9th of August. You are told that parties must have their own agents to present things here. My petitioner is not a political party. He is not a candidate, but is a voter entitled to participate in elections and to present a petition. The obligation, legally speaking, is on IEBC to provide a free, fair, and verifiable election. There is no obligation on a voter like Hele Khalifa to hire and recruit agents all over the country to watch how the elections are conducted. If you do so, then you will forever relegate the participation of the people of Kenya in a free and fair election to the ability to hire and deploy over 46,000 agents in all the polling stations to watch over their vote and the votes of others. The question was asked, the question was raised by Mr. Ngatia, that election officials are tired, they need to go back to work. Convenience again. I say this. Our constitutional values and provisions should not be sacrificed at the altar of convenience. If the election officials are tired and cannot do another election, please, we have more Kenyans who are willing to do this work properly. Give them that opportunity. And that ties to the point that was said, that Kenyans cannot be in elections in perpetuity. Kenyans must get it right. And I say this with due respect to this honorable court, that the Supreme Court has a higher obligation when it comes to this issue, to ensure that we get what we call regime legitimacy. In countries like DRC, once a presidential election is concluded, it goes to their Supreme Court, the Constitutional Court, to get a validation, regime legitimacy. That is what Helef is questioning here. In a fractious society, highly political like this, just remove that, highly political like this, a Supreme Court decision gives regime legitimacy to that new regime. And when questions are raised like we've done, then the Supreme Court, and when you consider the margin by which the purported declared winner has surpassed the victory, that legitimacy should not be granted by this court at this point. I want to address a few questions that were asked by the learned judges. Number one, by Justice Ibrahim, is there a lacuna in the law if we nullify, in God's grace, these elections? And, if we indict Wafula Chebukati? The answer is very simple. Article 142 of the Constitution, the president who is in office shall continue in office until a new one is sworn in. There is no lacuna in the law. The second point, Mr. Chebukati is not immortal. He could even resign from his office. Does it mean that this country can collapse if Mr. Chebukati resigned from his office today? No. Elections will still be held. We'll still have within our governance, we have a working parliament, we have a national executive, we have a judiciary. All these questions, all these issues can be addressed within those existing parameters. And when I say the president will continue in office, of course, within a narrowed mandate, but the systems and the functions of government will continue. The lacuna will not affect the people of Kenya. The right thing is to make sure that the people's voices are actually heard in a true, transparent election. My learned Chief Justice asked the question, why it took too long, why the Commission did not announce the results from morning. To corroborate that there was actually peace at Bomas, we had a choir singing the whole night and the whole day. If there was violence as was being presented here at 3 p.m., what stopped them from announcing at night those remaining polling stations, constituencies? What stopped them from announcing those constituencies in the morning? The choir is my witness. They were singing, there was peace, and everybody saw that. The other question that was asked by learned Justice, Deputy Chief Justice, about a dysfunctional commission, I wish to say this. The dysfunctionality of the commission has always been there. But it has been brought to us by what I call a celebrated group in this constitution. In 2007, Kipkirui, an individual clerk, came out and told us what is happening at KICC is cooking. In 2017, Rosalind Akombe came out and said, what is happening at IEBC is not being done in compliance with the orders of this court. And she ran away, she fled this country. In 2022, you now have the commission itself, by a majority of its members, coming out to tell Kenyans that what is being announced are not the product of the commission. Should those commissioners be vilified? Should a commission that has made an admission of a failure of Tier 3 be vilified? I say no. That dysfunctionality should actually now prove to you that indeed the Constitution is working. On the question that I wish the court to consider, what would have happened if we didn't have this court? In 2007, we didn't have this court. And those who had been said to have lost the elections didn't want to go to court when they were asked to go to court. Because to serve a president was almost impossible. The hearing of the petition would have taken forever, even 5 years, the entire term. This court should not leave Kenyans in a way that they start questioning themselves, do we still have an avenue through which we can solve these political questions? That is a core function of this court. If the court fails to stand up to occasion, the ramifications of the people of Kenya will be dire, because people end up losing trust. So I urge you that do not err on the side of convenience, to tell the people of Kenya that when we can see some of these problems, convenience requires that Chebukati cannot conduct an election within 60 days. Let us not upset the elections. It will erode public confidence in this particular court, which will be catastrophic, as we witnessed in the year 2007. Tied to the commissioners, there are affidavits, and I believe the commissioner will talk about them. In their reply, the majority commissioners in their replying affidavits have already, we must point out, number one, that these commissioners have been in office for less than 1 year. September marks their first year in office. Within that 1 year, they've filed they've written 3 memos on the conduct of the chair unilaterally making decisions. Ultimately coming out on the 15th to tell Kenyans what they had been dealing with internally of a unilateral, arbitrary, all-knowing chairman. And I say this as I conclude, my lords and my ladies. When an alligator comes out of the water and tells you that the crocodile is sick, do you doubt him? When the commissioners come out and tell you that our processes are opaque, our processes are not as per the Constitution, do you doubt them? I urge you, don't doubt them. We pray, my lords and my ladies, that you allow the petitioners prayed and grant the orders which are sought, and don't shy away if you find it necessary to indict Mr. Wafula Chebukati for the transgressions and the singular manner in which he has run the IEBC to the detriment of Kenyans. Thank you very much, my lady. I yield today 13 minutes of my time back to court. 30 seconds.
Thank you. Counsel representing the fifth petitioner, David Kariuki-Ngare. 15 minutes.
Your Lordship, the Chief Justice, Deputy Chief Justice, members of the court, may it please you that my name is Mamboleo. I represent the fifth petitioner in the consolidated petition. We'll be making this rejoinder together with my learned friend, Mr. Marara Umoke. Your Lordship, when we filed this petition, the response we got from the respondents was that this petition was frivolous. The other response, my ladies, my lords, was that the tallying, verification, and declaration of results at the National Tallying Center is a preserve of the chairperson of the commission. That the rest of the members of the commission have absolutely no role whatsoever. I can quote my senior colleague, Mr. Kamau Karori, as deliberately insisting that the other members of the commission, the 6, don't have a role. That in fact, the chairperson of the commission has been extremely magnanimous because at various points in this process, he's even involved them somewhat. The third response we got is that the election of the President of the Republic of Kenya is just about numbers. It is numbers, numbers, numbers. And then lastly, the respondents wanted to put this court in a dilemma, a catch-22 situation, by suggesting that should they exercise some powers under Article 140 of the Constitution and probably nullify the election, we are going to get into a situation that is uncharted constitutionally. Create fear. Your Lordships, your ladies, I want to suggest to this court, when you retire, to look at what we call the theory of false dichotomy. The theory of false dichotomy is an informal fallacy that is based on a premise that erroneously limits the options that are available. And what the respondents are telling you is that the Constitution does not provide mechanisms to deal with the situation that might arise for something that is expressly provided for under Article 140 of the Constitution. I also want to suggest to you, my ladies, my lordships, when you retire, to look at what came into the open about 3 years ago, which is called the CIA Rulebook on Disruption of Organizations. How do you disrupt organizations so that you do not have an organization working as it should? And when you have achieved that, then you come out and use the law to subvert the will of the people. On Bomas on the 15th of this month, of August 2022, it is now judicially noticed that the beaming of results stopped. It is now in public notice that commissioners of the commission, at least 4 of them, came out and stated that they do not have anything to do with the result that was being announced. It is actually admitted that as this was happening, top in the mind of the chairperson of the commission, he knew and understood the process of tallying, verification, and results to be his own preserve. He has not even refuted it. He says that is how he understood it. He said that the other commissioners had no role. So what do we want to suggest to you, your lordships, your lordships? It is a very simple thing. That the reason why Kenyans were so glued to the television sets for almost 6 days is because the election of president is the only one thing that Kenyans do as a collective every once in a while. It is so important to them that you simply cannot joke about it. The reason why your lordships and every Kenyan was glued to media stations for the 6 days is because you wanted to know what happened to your vote. So Article 138(3)(c), as read together with Article 38 of the Constitution, is in my view an expression of the greatest protection or the greatest gift that this Constitution has given to the benefit that is promised in Article 1 of the Constitution, that the people are sovereign. But if somehow you manage to capture the sovereignty of the people and set it aside by some scheme or something, then we are in a problem. And without taking too much time, because I associate myself with the submissions made by my Lana senior counsels here, the important thing that we want to suggest to you, your lordships, is that when you retire, could you kindly borrow something that I know you already know, that Article 138(3)(c) of the Constitution is the ultimate protection that Kenyans have been given with respect to the presidential vote in a presidential election. And if you do so, then I'm sure you will come to the conclusion that Article 138(3)(c) is a peremptory norm of the Constitution. It is a jus cogens norm of the Constitution from which no person is allowed to derogate. Not the IEBC, not the chairman, not the President of the Republic of Kenya, and by no means, not even the Supreme Court of the Republic of Kenya. That this court must enforce the fact that this is the highest Grundnorm with respect to the protection of Article 38 and by extension, the sovereignty of the people of Kenya. I will yield my remaining minutes to my colleague, Murara Moke. Thank you.
You look second hand yourself right now.
Mimi nakaondiek. Niangalie hivi, nakaondiek.
Not with those. Maybe with the tummy. No.
Tosha.
Huyu hata tujuani. Do you know me?
Arre baba.
We know each other.
Iko saying lines hapo.
When the husband ama ni houseboy? Houseboy. Mimi ndio ila kusumbua.
Wako ha?
Yes.
Jambo.
Hi, thank you. Oh my God. Yeah? No. Let me talk the truth and accept the devil, please. Please.
Babyface.
Yeah. Oh my
God.
God. Yes.
Babyface.
Yeah.
Ulionaje kazi yangu? Skills zangu zozaje zikoaje?
You are excellent.
Wewe mzee. Hatuko hapa mchezo.
Nifile hata na.
Sasa ukisha si uongee vile unaongea.
Mtu akiwa serious, amwe serious.
Life cannot always.
The outcome of an election that is conducted by what I could simply call the Tower of Babel, because the IEBC, when you have two factions of an independent commission, that is something so serious. It should concern not just the judges. I was happy when I heard Madam CJ, you said that you are very concerned by that, and I pray that you continue being concerned by that. as you retire to make your determination, and that all of us in this country be concerned by that. That we had a commission that has two factions, that is run by what has been described as an executive chairmanship. I was very shocked. I could not believe what I was hearing today. And this was being said by counsel instructed by that chairperson to come and tell you that he is an executive chairman. You should not accept that kind of description. It's not provided in anywhere in the Constitution. You read Article 88, which establishes the IEBC. It establishes a commission, not a chairmanship. Article 249 of the Constitution, it establishes independent commissions, and it requires that these commissioners act independently, and they should not be under the direction of or authority of anyone, including the chairperson of any particular commission. The 7 commissioners, each of them independent, they are not to be held hostage, as they have been held hostage by the chairperson, who says he's an executive chair, and who not only says that, but also instructs his advocates to declare him a national hero. I think that is ridiculous. In my opinion, if there is any heroics that we should be applauding, all of us, is the 4 commissioners who are courageous for their courage, that they came out and said there is a problem. Because in this country we must learn to speak up, we must speak out when we see a problem. And on my level, as an individual, I applaud them. And I think that what we should be applauding, we should not be praising things that are seen as unconstitutional. Very quickly, I would like to highlight other provisions of the Constitution that I think that should be looked at very keenly, and there was no compliance with that, which should lead the court to determine that there was no free and fair election. Article 10. Was it fair and transparent? We cannot say that, because if we have a result that has been tallied and verified by a few commissioners, that the majority of the commissioners are not given the opportunity, or we have some results that were not verified, then how can we say that that's a fair and transparent election? I ask you to look at Article 81, the general principles for the electoral system, which talk about a free and fair election that is run in an efficient manner, that are free from any corruption. But we've had many shocking things, that in our country we can have foreigners, even from the failing states, taking advantage of us, our systems, our people, and our electoral system. And the court should rebuke that kind of a thing. We should not allow it to happen again. It's a shame that, indeed, this is making us a laughing stock in the world. Everyone is laughing at us, that we cannot carry on our own process, a simple process of tallying results and declaring them. But there's always a problem. When we could see the IEBC spending more time entertaining us with their music, instead of announcing the results. It was very irritating, I must say, as a voter, when you cannot find the results from the commission, but you find music that you could play very freely on your own devices if you wanted to. Article 138(3)(c) is very clear. It has stated that the role of tallying, verifying, and announcing the results is vested in the commission. 138(10), by referring to the chairman as the one who is declaring the results, is simply delegating that responsibility to him. And even if the chairman was not there, that function would still be carried out. If you look at the IEBC Act of 2011, Section 7A and B, it clearly provides what should happen in case there is a vacancy in the position in the office of the chairperson of the IEBC. Things will go on. Nothing will stop, as the chairman would like us to believe. Everything will be carried on, even if the chairman was not there. And should this court find it appropriate to declare that there is an element of breach of Chapter 6, the court should try and make that determination, and other processes can follow. As I close my presentation, because I have 1 minute, I would also like the court to consider very carefully whether we indeed have the threshold to declare a candidate as having won this election. As we speak now, we cannot determine whether we are not sure about the total valid votes that were cast in this election. And without that, we cannot determine whether we have a 50+1 threshold. And I ask the court to look very carefully. In my opinion, we do not have that. There's a lack of clarity. Mahat's presented figures, which I would say many of them were based on presumptions, and projections. And that's not what the IEBC should be doing, not give us projections. That is for the analysts to do. Independent analysts can give us projections, but for the IEBC, they must give us specific figures. They cannot give us figures that are merely projections or made or based on presumption. The figures of how many voters were astray, how many ballots were astray, should be verifiable. I urge you, my ladies, and when you sit to deliberate, let's make things right for our country.
Madam Chief Justice, kindly permit me to seek your guidance. I also appear in the same matter. There were some two specific questions that were put to me by Justice Lenaura and Lady Justice Joaquin Ndung'u. I will only take 3 minutes and attempt to answer them. Madam Chief Justice, the question was put to me to try and link my arguments with the issue that we are canvassing here in respect to the number of the constituencies that must participate in a presidential election. To attempt to answer that question, Madam Chief Justice, permit me to refer the court to Article 136 of the Constitution, which provides that the president shall be elected by registered voters in a national election conducted in accordance with this Constitution and any other act. That election, the directive of how that election is to be conducted, my lady, is found under Article 138, Clause 2, which provides that if 2 or more candidates for presidents are nominated, an election shall be held in each and every constituency. And therefore the question is, the use of the word, or deliberate use of the word constituency is deliberately used by the Constitution, and these constituencies are determinable. And if you want to determine these constituencies, you therefore go to Article 89 of the Constitution. You also further go to Section 2 of the Election Act and see what defines this particular constituency. Why is it important for us to factor this in? It's because any voting that was done outside the Republic of Kenya that is not contemplated by Article 5, which defines the territory of Kenya, then any vote that was cast is an illegal vote, is an invalid vote, and it is a vote that goes
Madam Deputy Chief Justice and members, honorable members of the Supreme Court, I wish to respond in 15 minutes, which I shall share with Mr. Okiya Omtata to break down the figures to show that the threshold under sub-article 4 of 138 was not satisfied because the numbers simply don't add up. But I will make a few remarks, Your Ladyship, because there are a few questions that I needed to respond to as well. It is now clear that the ipse dixit of the petitioners on the question of compliance and non-compliance of the Constitution is now sound. And clearly Articles 81 and 86 are in question on compliance. The respondents, my lords, have put up, the second respondents have put up a self-righteous and pompous response on the question of the role of the chairman. And I want to just respond in this manner, my lords. Section 5 of the IBC Act defines what a commission is. And a commission is defined to include the chairman of the IBC and the members. That definition, my lords, contrary to the submissions by Mr. Karori, Senior Counsel, does not include and expressly excludes the staff of the commission. It cannot therefore lie in the mouth of counsel to submit that the verification and the tallying of the results of the presidential elections, insofar as Form 34As and 34Bs were concerned, was done by the staff and excluded the commission, who were confined to other duties. My lord, that was a violation and an infraction that expressly went against the requirements of Article 138 3C. Secondly, my lords, the submissions by learned friend, Senior Counsel, Professor Githu Muigai, on the executive status of the chairman of the IBC, I think should be taken with a pinch of salt, because Article 249(1) of the Constitution does not contemplate an imperial chairman who is all-fearing with fear, favor, fervor, and fiat. That is not the chairman that we have. The chairman of the IBC, appointed under Article 250 sub-article 4 of the Constitution, must be that chairman who is the first amongst equals, just like the Chief Justice of the Supreme Court. A primus inter pares who must work with his colleagues to guide the affairs of the Commission. I urge the Court, therefore, to decline an invitation by Professor Githu Muigai that the chairman of the IBC is in a special position, different from the 4 commissioners who are crying aloud to be heard by this court. And my lords, this petition number 5, as consolidated, therefore tilts on the violation of Article 138 3C. It tilts on that violation. And that violation alone, my lord, therefore invites this court to look at or to turn to Articles 23 of the Constitution on your role as a court to interpret the Constitution in a manner that goes beyond just protecting human rights, my lords, but to look at what would guide your interpretation, the holistic approach, the purposive approach, and let me borrow my learned friend's approach, the Antonin Scalia's approach, the late judge of the U.S. Supreme Court, the textual and the contextual approach. And if you apply those approaches, my lord, then you will find that the chairman of the IBC, in failing to properly construe his role under 138 3C and 138 4, violated the Constitution, and an unconstitutional process therefore emerged that cannot put into place, my lord, a process that violates Article 3(2). My lords, there is an invitation to you to invalidate the entire process And that is why, in answering in answering the Supreme Court judge's question that was directed at me on remedies, I wish to state that, and this is because this court also has a purpose under Section 3, the Supreme Court Act. And given that you're an election court under 84, in an ideal situation where you are construing Section 83 of the Elections Act, which must be interpreted disjunctively, because if there's an unconstitutional act, then the election cannot stand. If quantitatively, as we shall demonstrate, there is non-compliance, again, you'll have to invalidate the election. But my lord, in an ideal situation where you'd have been called upon to apply Article 232 on public service and Article 201 on public finance, you would have ordered a recount and then secured a winner. But this would only have been possible if there were no unconstitutional infractions that undermine the process and therefore make it unconstitutional. Because this is no longer about tallying and verification. It is about the bigger process of the involvement of commissioners and a split commission. And the only remedy available, my lords, Justice Ouko, the Chief Justice and member of the court, is a nullification. This is no longer the baby of Raila Amolo Odinga V. This is no longer the baby of William Samoei Ruto, Doctor, the first respondent. This is the baby of Wanjiku. It is the baby of Kenyans. Return this baby to Kenyans to determine to whom they shall hand over the baby after 60 days. I pray that you nullify the election. And I will cede my time now to Mr. Senator of Busia County, Okiya Omtatah, the perennial litigant. Thank you.
Distinguished honorable members of this court, I'll begin my submissions by requesting that my PowerPoint presentation be played.
Just to respond on points of law.
My lady, there was a question that was posed by Justice Ouko.
Yes.
To which Mr. Mohammed answered.
Okay.
And I would like to make a clarification on that. On the points of law, I think Professor has covered.
Okay. So you're only answering the question by the court?
Yes, my lady. Could the time be stopped, please, so that yes, we are going to interrogate the figures that were used here to attempt to mislead this court. I'll begin by asking the officer to play the slide number 6. That slide that contains results, when I looked at it and my other co-petitioners, we found that the maths did not add up. And that for us was a smoking gun, because figures don't lie. So, and I would also ask the court to realize that the comments we made about that particular result have not been challenged. That when you add the totals for the individual parties, you don't get the total ascribed. But the total ascribed is available in the workings and the affidavits of the members of the commission, which means we are dealing with fiction. I would request that you go to slide number slide number 5. And the Honorable Judge asked, how are these things transmitting? So when you look at the fact that at 17 hours, we had 21,481,652
voters or returns which had been made, and we factor into the, when we try to calculate the average number per voting station, we were told we are given 46,299 polling stations. If you divide 22,120,458 by 46,299, you arrive at an average figure of 478, which is not very far from when you take 65% of 700, which is the maximum number you can have in a polling station, you end up with 455. So when you now come and using the 478, which is the average we have had, and divide 21,481,652, you get 44,962. From paragraph 29 of Mr. Chebukati's replying affidavit, the figure he gives is that 45,994 kids reported. Now, from this, you already see that if the kids were 46,299 and 45,994 had reported, you are only left with 305 kids. These are kids which had connected, so the question of saying that these kids were looking for connection is not there. These kids were connected and they discharged their mandate. And you have been told here that there were some kids in Eldoret who are pinging, the same, who are sending results from Eldoret, I don't know from wherever, one kit being used. So at that time, you get that the 305 kids, which may not have had network, if you multiply that figure by the maximum number of votes available, you will find that the 700, if you multiply that, you'll get a figure of about 213,500 votes. That's the maximum that could be transmitted, not 2 million votes. And also, if you went by working of 1,337 kids, then the maximum amount you could get is 638,806. So the KIMS kits that transmitted are not these ones that reported at that time. But the data, the fact that they held so much data was mined. So somebody could transmit remotely, mining the data that was already reported in these polling stations. And that's how the fraud happens. For the workings on slide number 2, well, you can clearly see that if we use the 21,481,652 as the baseline and the 12,065,803 as the baseline, you find these workings coming out, and you can see that 1.6 million votes are being submitted between 17 hours and 2045, and on and on. But most important, even if we were to buy the idea that they were connecting, you have got 508,647 ballots on page 3, slide 3, which transmitted after a period of 3 hours and 45 minutes. So those particular transmissions of 508,647 are a figure that's very curious, because if you deduct the tally for Eldas from this figure, you hit almost the exact figure that Mr. Willis, Land Council Willis, has presented to this court, coming from the KPMG audit, that there was that number of voters, there was a number of ghost voters equivalent to that one. When we go to the other thing that supports our position, there was a question of what was the denominator used for voter turnout. I will invite you to look at at the petition at page 41. There's a letter, a press statement signed by Mr. Chebukati, saying that he used he used the National Voter Register to calculate, and if I may just read it quickly to the court. So page 41 is 141. It says, paragraph 2, at around 4 p.m., 12,069,803 registered voters out of 12,065,803 voters out of 22,120,458 had cast their vote. This equates to 56.17% of voter turnout.
How much do you need? Because we have that slide. Could we give you 2 minutes to finish?
You will refer to the slides. So, when I look at that, you'll find that there's no basis for claiming that the figure that claiming that the Kim's kits were used as the denominator. It's not possible, and it's not there. Also, I would like this court to take note of how the percentages are being played with. That's slide number 10. You'll find that wherever the chairman is reported 12,065,803 people voted, who voted represented 56.17 of the total registered voters of 22 that. At paragraph 26 of the replying affidavit, Mr. Sunkuli, using the same number of voters, 12,065,803, but as reported by the chairman, but again as a different number as a denominator, he arrives at the same percentage. So there you can say they can play with numbers by changing the denominators and arriving at magical figures. So my members of the Honorable Court, my prayer is that my submissions are that these figures are cooked, they were worked backwards to achieve a certain figure, but fortunately on the Form 34C, the smoking gun is seen. And since figures don't lie, and if the math doesn't add up, then this court should quash the results. We were told about military precision. Military precision is the ability to shoot a bullet with a bullet. That's how a missile downs another missile. That is not what we are saying here. There's no military precision in these figures.
The last petitioner, 7th petitioner, Julia Nyoka Biche, and others.
May it please you, Melody, Madam CJ, and other members of the court, to go straight to the issue. I've had a lot of Shakespeare and other learned fellas. I went to public schools. I may not be able to remember anything about Shakespeare, but Madam CJ, besides a Greek philosopher known as Plotinus and Adam Smith, my favorite philosopher is called Karl Marx. And one of the most famous quotes that he made is this, that history repeats itself, first as tragedy, second as farce. Now, I go to my issue. Yesterday, Madam CJ, when I was listening to my learned colleague, Mr. George Oraro, Senior Counsel, I could not fail seeing the echoes of 2007 in what is happening today. Madam CJ, in 2007, the secretary to the commission, just like this year,
was at the heart of what happened. The secretary was called Suleiman Dongo. Suleiman Chege. The secretary today is called Hussein Marjani. Same problem of numbers. The Kenya law reports would bear, and Mr. Isa Mansour is also here, that I represented Samuel Kivuitu and others when they were removed from office. Now, it turns out that, and listening to my learned colleagues, that just like in 2007, the person who knew why the results are like that was Suleiman Dongo, Suleiman Chege. Listening to the presentation yesterday, it also appears that the only person who really can tell us about these numbers is Hussein Marjani. Second similarity is that both Raila Odinga and William Ruto were at the heart of what happened in the year 2007. But that is not the more important point. The more important point is the differences. The differences were these. In 2007, and under the constitution that was existing that time, the election was announced on the 30th of December 07. And the president sworn on that day assumed office. But the difference this year is this: after 15th courtesy of the new constitutions, on the 15th of August when the declaration was made, the person designated as the winner by Chebukati became president-elect. That's an important distinction. The second most important distinction is this: that the former constitution of Kenya did not have an equivalent of 138 of the constitution. There is that distinction today, which is what I was calling stage 3 of a presidential election. It was never there. The next issue was that in 2007, the presidential elections were held by the High Court under its original jurisdiction and special jurisdictions of elections. This one comes to the Supreme Court, and the basis upon which that is done is on the basis of Article 140 of the Constitution. There is no sitting president who will be appearing before you. There is only a president-elect. Now, my first petitioner, Julia Chege, asked me, because there was a subjective question that was posed in her view by Judge Smoky Nwanjala, that how come there was no protestations by these people when they were being given domestic chores? According to Julia Chege, who had to resign from her university job as a lecturer, there is something that needs to be understood. That for 99% of the human population, you want to follow the natural order of things. You don't disturb things. You let them things as they are. So that to Julia Chege, it is important that the court must understand that from your point of view, a lot of you, and she knows that history, have had a previous opportunity to stand up for something, an opportunity to say no. Not everybody has had that opportunity, and therefore, the 4 commissioners for ultimately, on the 15th, having the courage to have something to stand for. They are heroines and heroes of this country. We come now talking about heroes to what my professor of criminal law and procedure, Dr. Githu Muigai, said. Dr. Muigai, looking straight to the face of this court, said 2 things. A, the problems in our elections is not IEBC, but the candidates. History does not support that conclusion. Second thing he said, B, Wafula Chebukati is a national hero. I don't have to say anything on that. Now, Madam CJ, there is an issue of the word independent, or in the designation of IEBC. The word independent, it is further elaborated by under Section 26 of the IEBC Act. It says IEBC is independent, but shall be subject to public participation and to engage stakeholders in the discharge of its mandate. Madam CJ and members of this court, I flatter myself quite often that I have a reasonable understanding of Kenya's electoral laws. However, Madam CJ, listening to my learned colleagues yesterday, I had a lot of reasons to doubt whether that is true, if what they said is actually the true representation of the law. And in several senses, under Article 81, the election should be simple, accountable, accurate. But until yesterday, my understanding was this, that reference to the Commission and Article 81, 86, 88, and 138 of the Constitution triggers the image of Chebukati and 6 others. I've never imagined Marjani and others returning officers when we talk about the Commission. B, based on sections 10 and 11 of the IEBC Act, my understanding has always been that the Secretary of IEBC is the chief executive, the head of the secretariat, the main employee of the commissioners, who appoints him. But now it appears to be that for purposes of a presidential election, and we heard it from his lawyers, he's actually the main man. Was this what the Constitution wanted it to be? Welcome to the Republic of Kusadikika. I must agree with my learned colleague, Mr. Muthomi Kiethiankulu, that it would appear that since we did our elections, we became some kind of a terrestrial Kusadikika, and several questions arise. When, why, and how? When did this happen? It first happened just before midnight on 9th of August, when we retired to bed. One figure we ought to have had was not known. How many of us voted? That is the when. How did it happen? It happened because on the 8th of August 2022, Wafula Chebukati published that Gazette notice that I talked about. On the face of it, makes the chairman a dictator. No, that is not the issue. If you read it as an instruction manual, it was to give the job to Hussein Marjani. That is what happened. Why did it happen? It happened, and we explained in our affidavits, paragraphs 42 to 45, and what they say that effectively, on the 15th of August, when these elections were declared, from 7:30 to 6 p.m. on that day, the Commission, as a Commission, had lost effective control under Article 138 of the Constitution. I come because I'm trying to rush myself to the petition, number 7. This petition, Madam CJ, is actually a numbers petition. I didn't want to make a lot of fuss that I would have needed more time, but in case my mouth does not go fast enough, I urge you that you give me a little leeway to conclude what I need to say. The issue is this, Madam CJ. When you pose the question that you posed, how do you have evidence 700,000 people did not vote? You triggered some kind of public participation on my phone. I had many calls. Kibe, why did you just say it's 700? It's about 3 million. But of course I had to tell them, no, we just said 700 because we had some kind of evidence. So it's a big issue, Madam CJ, that you triggered a public participation. So many people don't vote on account of non-enforcement of Regulation 90 by the IEBC. Now, for whatever the value is this, I can demonstrate very shortly, and we've done that in our petition and in our, in our affidavit, that when you have a petition based on non-compliance, how do you prove it? We have an affidavit of Julia Chege that basically has not been controverted. She says where she was voting. She was voting as an MP she was contesting the office of Kangema. And she said how she interacted with election officials. There were no affidavits sworn by the commissions to say those interactions she talked about were not true. But more importantly is this. When you say Regulation 90 says you are going to publish notices on how election officials and security officers are going to vote, IEBC needed to do a very simple thing. Namely, what did you publish to implement it? If you didn't publish anything to implement it, you are responsible for non-compliance. How do you treat non-compliance? You tell the Supreme Court. We could not be able to have non-compliance for reason A, B, C, D. Then the Supreme Court may decide to excuse you or not. But in the absence of that, non-compliance has been proven. What is the effect of this non-compliance? We have stated in our further affidavit, it's a numbers thing. If 700,000 people did not vote and you adjust it whichever way you want, you will still have a figure of 300,000. So the long and short of it, my ladies and my lords, is this. Unless you excuse IEBC and they did not ask you to excuse them, then you must find that the numbers in petition number 7 could have altered if those people had voted the results of the general election. And therefore, it is not permissible for anybody to be able to say, oh, it's a numbers thing. Petitioners brought no number. We brought numbers, and there was no response. We come to the issues of the issues of the procedure under Article 138. Under Article 138, that's one of the best done judgments that I've read. I've read it many times. It was written by artist Judge Jouko was there writing it. Catherine Mantoinoti was there. He was my people master. One of the best written judgments. I've read it many times. But yesterday, it somehow appeared I don't understand these things. So I read one more time yesterday night. And I thought, I think I understand what it says. So it was violated in 3 major ways, my lady. Number one is this, issues of the voter turnout. The issues of the voter turnout until yesterday, I thought is usually settled before the elections through the gazettement of a voters register. For these elections, it was done on the 21st of June 2022 through Gazette number 7290. But listening to my learned colleague, Mr. Somane, it would appear that fairly educated people like James Orengo, Firoz Noroji, Paul Mwangi can actually write petitions, and they were told in open court they did not understand what is all this about Article 190. And I also shuddered that if they didn't understand, probably I also did not. Issues number, the second failure is this. In short, I'm saying the register cannot be mysterious. If the register is mysterious, the election is not simple, does not meet the requirement of Articles 81 and 86. Number two, the stoppage of the public display. I didn't hear a straight answer to that. Now that there was no straight answer to the issues of the failure of results, and the 27 were not read, that goes straight to the root of the procedure under 138. If that was not done, my lords, there is no way in which you can be able to say the election was valid. For a simple reason, which is this. That when can I have 2 minutes? 2 minutes. Yes, I can give you 2 minutes. For the simple reason that under we were dealing with under article for the conclusion. The whole point about Article 138 is that the procedure must be concluded. If it is disrupted, you have to hold that Article 138 was violated. The next issue is this, the third one. We talked about the issue of effective control. If you are convinced by what you have heard, and we have gone through this in the last 2-3 days, that IEBC lost effective control from 7:30 on the 15th to 6 p.m. when the results were read, there can be no basis for this court to say anyone was validly elected as president of Kenya. My learned colleague, Mr. Fred Ngatia, whom I respect a lot, said that William Ruto won these elections fair and square. That expression, fair and square, to my mind, comes from, as I understood, the famous judgment where Judge Madan was in the Githunguri case, where the basic point was this, that certain issues may happen that may make even a person who on the face of it could have been liable for criminal offenses not to be properly tried. And therefore they said it makes any conviction to be bad in law. You do not have a fair and square deal. Under Article 138, Raila Odinga, the other surrogate petition, they need a fair and square deal, that their votes were not enough. Finally, my lady, the Chief Justice, Article 138 must not die in your hands. We are most obliged.
I think that brings us to the end of... Yes, that brings us to the end of Rejoice Us. We are looking at Senior Counsel Mr. Mwite, but we know very well your clients were respondents. It was only for the under representation that we allowed them to come just after the petitioners. They do not have a right of rejoinder.
Chief Justice, I am acutely aware of the time constraints within which this Honorable Court must adjudicate on this petition. And may I say that this Honorable Court is entitled, suo motu, to decide that the 14 days specified in Article 140 mean 14 working days. Yes, to exclude Saturday, Sunday, and public holidays. You can do that, suo motu. I am pleading, Chief Justice, I'm pleading on behalf of the 4 commissioners. I plead. They have had very, very little time in this court. I plead.
Well, that is why I was looking at you with the questioning eye, because
Yes.
there were some questions also which were asked, and they need to be responded to.
Yes, those are the ones. I'm just pleading.
Yes.
Allow my colleague Mansu Issa some 8 minutes, and Dr. Arroa some 3 minutes, and yours truly some 2 minutes only.
That is 15 minutes.
Because, yes, because...
To answer those questions.
No, because, Chief Justice.
Yes.
Those questions directed at those 4 commissioners are very important. And
Thank
when
you.
others were answering questions,
Yeah.
a lot of maligning, a lot of... Please give them that opportunity to have their case stated. They are the majority in that commission.
Thank you, Senior Counsel. I think we've heard your plea because we asked questions. So we'll give them 15 minutes to answer, not now. We want to take a break. And immediately we finish, there was an issue raised by Senior Counsel Gatia responding to some two Forms 34, and you asked for 5 minutes. And then we will give the parties 15 minutes, not all the parties, the ones who are connected with the discovery and the scrutiny, 15 minutes in the afternoon to respond to the report.
I request, Madam Chief Justice, may I request 5 minutes for the Commission, because we are the custodians of the form, the legitimate forms.
Yes.
And my learned friend, Mr. Orengo, needs his lunch now. He's heckling.
Okay, we'll give you 5 minutes, and the court will arise.
Well, there you have it. It is the live pictures from the Supreme Court. The judges have retired for a couple of minutes, and then they will be back for the last rejoinder. Remember, it is the third day of hearing, and the last being the rejoinder day, the hearing before the 7-judge bench. And after that, they are going to be retiring to make a determination on the Raila Odinga and Martha Karua petition, live from the Milimani Law Courts, where the Supreme Court has been domiciled for the better part of this week. Of course, a lot has been talked about in matters rejoinder, but something has just come up and just would not go. If you look at the social media platforms, there's a lot talking about names of judges and how they've been carrying out themselves and lawyers, but one name has refused to just go away, and that is Jose Camargo. After one of the Form 34A has been identified having his name. And flashing back to July the 21st, you do remember there were 4 Venezuelans who had landed in Kenya with some IEBC election materials, and Jose Camargo, if you like, Oje in Spanish, Camargo was one of those people. That is Jose Gregorio Camargo Castellano. And the name itself, just one of the issues that has made part of the submissions in this morning. And other than that, of course, the rejoinders by all the petitioners. Remember, they were all consolidated into one petition. My name is Ben Troinjue, and for now, let's look at exactly what has just transpired. I'm joined by a constitutional lawyer, Henry Kurauka, who we have been having for the better part of this week. Thank you so much, Counsel, for making time. I don't know where to begin because a lot has just transpired, but the name, Jose Gregorio Camargo Castellano, just refuses to go away after it was discovered in one of the forms. How does this pan out when it comes to the submission? It was not in the original submissions that were made, but it has just come up on the day of rejoinders. Actually, it's the one that is trending on Twitter.
Thank you so much. I think that is a very triable issue that has arisen because it touches on integrity of the information, the results, and it is an issue that the judges should determine. When a party is involved in uploading those forms, then that party must be authorized by the commission to do so. And if there is any foreigner or maybe an authorized person doing so, then that becomes a serious matter. But we hope the judges will be able to analyze the evidence and make a decision on that. Another issue that is coming out very well is the division of IEBC commissioners. That is another very serious issue that has arisen, and which we expect the honorable judges to make a decision on, because on one side, I remember my lecturer, Professor Gidu, saying the commissioner did a fantastic job, but on the other hand, the petitioners are saying he did it alone. He shouldn't have involved the other commissioners. So we need now the honorable court to render a decision, an opinion as to where the role of IEBC as the commission ends and leaves the chairperson to announce the results, because it's a process. You know, there is the issue of counting, tallying, verification. That is squarely the role of IEBC pursuant to Article 138, subsection 3C. But when you read Article 138, subsection 10, it is the chairperson to announce the results.
And another pertinent question that has come up regarding why the chairman of the commission, Wafula Chebukati, indeed they've talked about there was some violence and some chaos, to the point that they even presented a video in court to support that. And the question was, actually was raised by one of the judges, that the commission chairman had a day to put his house in order, perhaps try to reconcile with the 4 commissioners so that they may come up with one cohesive report, and that is to announce the presidential result. And also something that has also come up is that they are questioning or quizzing why Kenyans were glued to their screen. But unfortunately, there's a time that came that the results the portal they stopped displaying those results. There are some issues that are going to come up.
Yes, I think the issue of violence, though it is featured, I don't think it's a very serious issue related to the petitions. The reason being that on one side we have some lawyers saying, yes, there was a quiet entertaining Kenyans until very late, and that could not have happened if there was continuous chaos. Others may argue that yes, there was some chaos, but they did not last for long, or they did not substantially affect the work of the chairman. It's unfortunate that some, IEBC officials were injured. My view is that the judges will have to look at the law as it is, and the procedure of elections was the tallying, verification and counting done within the law. If the answer is yes, then they will ask, was the elections free, fair and transparent as per the Constitution and the Election Act? If the answer is in the affirmative, they will proceed to validate. Remember, the jurisdiction of the Supreme Court is derived from our Constitution, which gives the court the singular mandate to determine election results relating to the presidential elections. And as one lawyer rightly put it, like for example in DRC Congo, the Supreme Court proceeds to even validate the results even without a petition filed. So you can see how many countries have placed the court in that respect. Of course, there are many other aspects relating to the election that the Honorable Court lacks jurisdiction. For example, the orders that Moses Kuria was requesting were completely out of the jurisdiction of the court. The issues like violence, unless they touch on the integrity and they affect the final results or the election,
those become issues. Some issues that have arisen and have been raised by various parties are not issues for this honorable court. They can be raised to the police, investigations can be done, action can be taken. Other issues should emanate from the other courts. For example, if IEBC commissioners have any issues relating to their performance, I think some of those issues relating to how they manage their day-to-day activities should be referred to the Employment and Labor Relations Court first for determination. And that's why the Supreme Court rightly refused to be involved in determining their legal team.
Yes, and my director informs me we need to go to the news, but before we do that, Article 138.10 on a declaration by the chairman of the commission, but looking at even 2013, 2017, the issue of the server has always crept up in terms of the elections petitions, and one of the issue is, of course, the DCI also talked about when it comes to servers, a lot of people had administrator rights, of which has raised a lot of questions, including Jose Camago's name has also appeared again. This is something that we have done in 2013, talking about servers, 2017, talking about server. Now we are also in the same place, talking about server, and also a new one, portal.
Yes, in its judgment, we expect the Supreme Court to make guidelines to render an opinion or opinions in respect of all those matters. Yes, it is true. The chairperson is supposed to announce the results, but the chairperson cannot announce incorrect results. These results must meet the other standards set out in 138 subsection 3C, whereby the commission is supposed to do all those other processes of counting, tallying, and verifications, and so on. So the final results should be accurate.
Thank you. And let's now cross over to the other side. We are keeping a keen eye. Remember, the judges have just retired for a break, maybe a health break, but they will be coming back. Remember, it's the last day before the judges do retire to make a determination that we do expect on Monday, very early in the morning, and we expect to see how that pans out. Let's first of all have a quick break as we still monitor what is happening at the Supreme Court. We'll be back with the news. I can see Nisi Mano is on standby, but let's take a quick break. We'll be right back.
Second hand? You look second hand yourself right now.
Mimi nakaondiek. Niangalie hivi, nakaondiek.
Not with those. Maybe with the tummy. No. But
Tosha.
Huyu hata tujuani. Do you know me?
Are baba. Iko feng lines hapo.
When the husband ama ni houseboy? Husband. Nini wewe inakusumbua?
Makoha.
Yes.
Jambo.
Fine, thank you. Oh my God. No. Let me talk the truth and accept the devil, please. Please.
Babyface.
Yeah. Oh my God. Like that. Yes.
Babyface.
Yeah.
Ulionaje kazi yangu, skills zangu za uzaji zikoaje?
You are excellent.
Wewe mzee. Hatuko hapa mchezo.
Ni kweli hata nani.
Sasa ukisha si uongee vile unaongea.
Mtu akiwa serious, akuwe serious.
Life cannot always be too serious.
Yeah man, what's up here?
Hello?
We've got to take some time off and laugh and laugh. And we tickle you down with lots of laughter.
That's why I'm saying I'm who is who.
Huh? With satire like no other.
Tell him to bring it on.
Dakachapa.
What about Zeno? You broke the rule for him.
Are you saying he might remain unconscious forever?
What you forget and what you don't is up to you to decide. But a word of warning. There's no way to undo this portion's effects.
But with enough time, you'll pull yourself together and focus your attention on our kingdom.
Indeed, a very good afternoon to you. Thank you for joining us here on KBC Channel 1. We do continue to bring you updates on the presidential election petition hearing that has been going on for days. We do have our colleague